realize that everybody has different stories about how they came here to Niles, Michigan. But I wanted to give you some general background information so that you're aware of what the laws are, how it's set up here in the United States, and then we'll open up for questions. And when we open it up for questions, I want to make sure that you're aware that I don't want to, if you ask, say like generally, those are the questions over here today, like just general, because everybody has their own personal legal issues. I don't want to bring those up, and that's why we're making ourselves available after lunch, so that if you have some specific questions, we'll be happy to answer them in a private environment, so that not everybody knows what your personal issues. Okay, so when we talk about immigration, I want to be able to identify who are the folks that we talk about. So generally speaking, we begin with the person that has the most rights and the ability to travel freely and remain in the United States and not run the risk of being deported. And those are U.S. citizens, right? That's somebody that was either born in the United States. If they were born in the United States, then you're a U.S. citizen. Or if you were born in a territory, you're a U.S. citizen. Some of us may be fortunate enough that we had a legal permanent residency, and once you have that, then you have an opportunity to become a U.S. citizen. That's called naturalization. And others, believe it or not, when we're born, it may be that because our parents were U.S. citizens, then we're able to derive citizenship from them. And so that's how you would be a U.S. citizen. The next group of people that we usually see here in the United States are legal permanent residents. These are individuals that have permanent residency. So that means what, Antonio? If you're a legal permanent resident, what does that mean? Yeah, see, excellent. That you can live here permanently, you can travel permanently, and you can go inside and outside of the United States. But when we talk about legal permanent residency, is it really permanent? How is it that somebody who has legal permanent residency might lose their residency? By leaving the country?
On the Zoom.
Oh, okay. They didn't realize.
By leaving the country, committing a crime, other transgressions, I don't know.
Yes, absolutely. See, a round of applause for the students. Absolutely, that if you're a legal permanent resident, you can lose it by committing a crime, by leaving out the United States for longer than 6 months, or really if you're outside the United States for longer than a year, or going through other transgressions, exactly like Antonio had mentioned. So in other words, it's not permanent. And sometimes we may have parents who have that green card but rather stay in Mexico or in the foreign country, and they only want to come visit the United States every so often. We can't let them go past 6 months without coming back to the United States, otherwise they lose that permanent residency. The other group of folks that we may see now are asylees and refugees. These are people that are not coming to the United States because they want to necessarily look for a better way of life. But why are they coming here as asylees or refugees? Shannon, I'll give it to you.
Because it would be unsafe for them to be in their home country.
Right. So they're fleeing persecution. Absolutely. Absolutely. So then those are asylees and refugees, folks that may have, at the end, an opportunity to be able to legalize their status. But in the meantime, they're here in our country. They're looking for protection because of what's happening in their country. Look at Ukraine. You look at the triangle, like Guatemala, Honduras. We look at Mexico. Venezuela, right? We have a lot of neighbors now coming from Venezuela because of what's happening in their country. They're coming here looking for protection. And then finally, we have non-immigrants, right? Non-immigrants can be students, right? You came here to study. You're coming to the United States for a specific purpose. I want to come visit Notre Dame and check out the football game. That's a specific purpose. I want to come here to study. You're here on an F1. I came to Andrews University. I'm coming here for this specific purpose. I want to come here to work. That's an H-1B. I'm coming here specifically to work. Those are non-immigrants. And then some can say that perhaps those are undocumented, people that come here unlawfully, may also be considered non-immigrants, because a lot of times people come to this country not because they want to stay here, but because they want to be able to improve their lot in the meantime and have every intent of going back to their country. And so that's when we talk about non-immigrants. When we're talking about family-based immigration, remember that first we have to identify a relationship with an individual. And that is that if I'm married to a U.S. citizen, or if I'm the parent of a legal permanent resident, or I am the brother of a U.S. citizen, I may be entitled to an immigration benefit. And if that's the case, I'm going to go through the agency that's called U.S. Citizenship and Immigration Services. If you want to go to a website where you get the accurate information, that's the website you're going to go to, is uscis.gov. There's two ways that we can become legal permanent residents. One is if you're already in the United States and you qualify, in other words, you entered the United States lawfully, or you fall under an exception, you can apply for adjustment of status. That's changing your status from a non-immigrant to an immigrant. You're adjusting your status. If you're outside of the United States or you entered the United States unlawfully, then you go through what's called consular processing. And so when you file, the people who have the best benefit are U.S. citizens and their immediate relatives. And then this one we talk about in class all the time. So what's the definition of an immediate relative?
Parent, spouse, or a child under 21 who's unmarried.
Exactly. And then Antonio, what's the benefit of being an immediate relative?
You get a special status when it comes to applying for adjustment of status.
Right. But when we talk about visas, because they're immediate relatives, what's that mean with regard to the visa?
Immediately available.
Right. That's the beauty about being what they just described. If you're an immediate relative, that's the parent of a U.S. citizen, the spouse of a U.S. citizen, child under the age of 21, unmarried, those individuals are immediate relatives. That means that there's no wait for a visa. When you apply, the first petition is called the I-130. When you submit that petition, and once that gets approved, or if you're eligible, at the same time when you apply the application for a green card, when it gets approved, there's a visa that's immediately available. But for the rest of the world, we have to take a look at this. And here I'll ask my friends in the back to go to the visa bulletin, if they can toggle to the visa bulletin. We already pulled it up before. It's the December 2023 in the back, if we can toggle to that. Yes. And then maybe make it a little bigger so people can see it, I guess. All right. If you're an immediate relative, you're in the category where you don't have to wait for a visa, right? But the rest of the world, everybody else, so we're talking about unmarried children of U.S. citizens, spouses and children under the age of 21 of legal permanent residents, sons and daughters, those are the ones that are over 21 of legal permanent residents, married children of U.S. citizens, and siblings of U.S. citizens fall under this preference category. And this is where we see how our immigration system is broken. So when you file an I-130, the date that they receive the petition is called the priority date. It's like your place in line. So let's say, for example, let me give you a date of April 30th of 2015. That somebody submitted the petition on April 30th of 2015. So then that's your date in line, but if we can go back to that chart, you're going to have to, I think it's Control-Tab. Or if you click on Visa Bulletin, it'll pop up right now as well. There we go. Yeah. Oh, I see it on my screen here, but I don't see it up. Okay, well, I can go off of, if you can imagine, there's a chart, right? And so it'll say the entire world falls under one category. Then it's Mexico, India, and the Philippines. And they're the countries that have the most serious backlogs. And when you take a look at April 30th of 2015, if you look, for example, at the chart for the Philippines, you won't be able to see it now, but if I can describe it to you, it'll show the Philippines, and you'll go down that chart, and you'll go down the preference category where you fall. And when you look over there, you'll see that for the Philippines, right now it's taking 23 years for a visa to become available. And for the rest of the world, it may be about 13 years. And so that's what we're talking about, this backlog with regard to visas. So if you're lucky enough that you're an immediate relative, you don't have to worry about that. But the problem is if you fall under this other preference category, you may be waiting a long time for a visa to become available. If I can go to the next slide, this thing isn't working now. All right. And I'll go to the next one. I can talk about that generally when we get to the next point. All right. So when we're adjusting status, if we were unfortunate enough that we entered the United States unlawfully, there are 4 ways that we might yet be able to legalize our status. What are the 4 ways that we might still be able to be eligible for adjustment of status, Antonio?
You are immediate relative, so you could use your immediate relative.
So if you're an immediate relative, absolutely, and you entered the United States lawfully, and you were inspected and admitted or parole, that just means that you went to the port of entry and they allowed you in. So if we came in with a visa, that's great when you become a U.S., when you're an immediate relative. But if you did not enter the United States lawfully, then the other exception would be 245I, that the petition was filed before April 30th of 2001, parole in place. If we have family members that were spouses, sons, or parents that were in the military here in the United States, then you have a means to be able to get a work permit, and once there's a visa available, to legalize your status here in the U.S. 245I, advanced parole if you have permission to travel outside of the U.S., if you had TPS and you came back lawfully. And then if you were waived through, if they allowed you to come in, even though you didn't have the right to come into the United States. So that's how we might be able to still adjust our status and apply for a green card here in the U.S. And then consular processing, that's for people that if you entered the United States unlawfully, that in the end you'll have to go back to your country to go through the consulate to apply for your immigrant visa, or if you were in the United States lawfully, but you fell out of status, in other words, maybe you came on an F1 and you fell out of status, then that way you would not be eligible to adjust your status if you were not an immediate relative. That may make you have to go back to your country. But when you leave your country, the problem that we have is this. Any person that's been in the United States longer than 6 months but less than a year and leaves, that person cannot come back when they leave for 3 years to the United States. And if you've been in the United States longer than a year and you leave, you can't come back for 10. And if you've been in the United States longer than a year, you leave, and you come back unlawfully, you can never come back. It's a permanent bar. So those are things that we need to consider, and that's why we have waivers. But the waiver is only available if it's a spouse or a child of a U.S. citizen or legal permanent resident. So just so that you're aware, so that was a real general outlook on how immigration works here in our system. I would say that USCIS is when you're applying affirmatively for an application. If we get in trouble with immigration, that's Immigration and Customs Enforcement. They're the ones that would arrest people with regard to raids, or they might stop at your work and they're looking for status. That's ICE. And then the Executive Office of Immigration Review, those are the courts. That's the immigration court system. And that's where we, if you're at risk of being deported, you would go to Chicago. Next year, we're going to have an immigration court in Indianapolis, so we'll be going to Indianapolis. Well, Indiana goes to Indianapolis. Michigan goes to Detroit. The court is in Detroit. And so then that gives a little bit about the general overview with regard to immigration. And I'll pass it over to Cecilia. If you have any questions, we'll be available at the end.
Okay, well, thank you. I wanted to bring up this issue of marriage because we know that at least in the United States, marriage is a legal contract, right? And with that comes different obligations and different responsibilities. But for purposes of immigration, it may be helpful, of course, if you do marry someone with status, United States citizen or legal permanent resident. But again, separate from your legal obligation within the United States and the state where you reside, there's additional obligations and responsibilities for immigration. And so we're going to, so Rudy went through somewhat of these, sorry, this is going in and out. Somewhat of these terms, right? So when we're referring, just so that you are aware of some of these definitions, a petitioner is the United States citizen or legal permanent resident. The beneficiary is the intending immigrant, so the person that wants to come and remain in the United States. When the petitioner's spouse is on active duty or is a veteran of the United States, then that person has benefits that they can provide to either their spouse or their parents. And again, Rudy went through that military parole in place. And it's not limited to having to sign up for the big military branches, right? It also includes like the Coast Guard, the reserves, and so if any of children or spouses have been in the reserves or have been in the Coast Guard, that also qualifies for this. So it doesn't have to be that they have to go to the Army or the Marines or anything like that. These considerations also include children under the age of 18 when the marriage occurs. So this is when either the children can benefit from the marriage or the intending immigrant can benefit from the child's status as well. For example, if their marriage occurs and the child is a United States citizen, the marriage must have had to occur when the child was 18 or younger, so that they can benefit from immigration benefit. Stepchildren, same situation. If the marriage occurred before the age of 18, and what are the requirements to prove that your marriage is legitimate? And I'll give this example because it is, to me, somewhat of a ridiculous question to ask. When I went in with an interview with one of my clients, and they did separate the two parties, and one of the questions that was asked was, what color is the front door to your house? And the husband did not answer correctly because, think about it, right? Think about it right now. Do you know the color of the front door to your house? We didn't when I first asked this question. And so these are the types of questions that I'm seeing recently. It's been a while since I've noticed that the immigration office has actually been actively going out and investigating the marriages. It seems as though recently they've been starting to do that a lot more often. So that's something to also be aware of. Rudy talked about this I-130 petition that needs to be filed. That kind of gets the ball rolling on whatever process in immigration you're going to begin, right? If your family member is petitioning for you, then it's the I-130 that's going to start that process. And that's why this visa bulletin is so important, because that's step number one from many different steps that are going to happen. So filing the petition, you must establish that the relationship is legitimate. I would argue that knowing the front door of your home, what color the front door of your home is not a question to establish whether the marriage is legitimate. You'll have to look at, and what should be looked at is, do you have joint assets? So are your bank accounts in both of your names, telephone numbers, your addresses on your, so whatever form of ID that you have are the same. Do you have children in common? How long you've been living together? Things like that. Okay. So here we'll talk about the obligations. And one of the most important obligations is financial obligations, right? So within a marriage, we know that there's general financial obligations that, you have to pay your rent, you have to pay the bills, you have to pay, between the marriage. But for immigration purposes, and we may be familiar with this form, we may not, but it's one of the requirements to show that the intending immigrant, the beneficiary, will not become a public charge. Within the last few years, we heard a lot about being a public charge, meaning that the person that is intending to come to the United States will not seek or obtain financial assistance from the government, because only United States citizens, with certain exceptions, only United States citizens can obtain that government benefit. But But that form that I'm referring to is the I-864, and that's the affidavit of support. So if you've gone through the immigration process, you may know what this form is. This is when they ask the petitioner, whoever's petitioning, for their tax information. They'll ask for tax information, financial information, sometimes, bank information. If that person, the petitioner, does not qualify to sponsor that person financially, that intending immigrant, then you can also file the same petition for a joint sponsor. So kind of like a co-signer telling the government that this additional person, maybe the petitioner can't afford to bring in the intending immigrant, but there's a joint sponsor that is willing to, put up their money and provide financially for this person. This becomes really important because, that's what we just discussed. So the obligations for a sponsor or joint sponsor are that they will provide the intending immigrant any support necessary to maintain them at an income that is at least 125% of the federal poverty guidelines for his or her household and size. And then the other obligation that is many sometimes overlooked is that we, as sponsors, we have to let the government know whether we've changed our address within 30 days of that change. That doesn't always happen. I haven't seen that be enforced, but it is an obligation that is stated in the form. And we can see here, and these, again, Rudy shared that website, uscis.gov, has much information. Those are the legitimate forms that one submits to immigration. Sometimes if you just Google the form number, something else comes up, use the legitimate forms on uscis.gov. But you will find this information, and this will direct you on the household size, and then you'll see whether if the person is in the military, then it's that middle section, but if anybody else will fall under this section closest to me. And so you'll see how many people in your household, so it would be all the people that live in your household plus one, because we're talking about the intending immigrant. So the legal effect of signing this form is that it creates a contract. In addition to whether it's the joint sponsor or whether it's the petitioning, the petitioning sponsor, it creates a legal contract between that person signing the form and the U.S. government. And that, as we know, in the United States, contracts are, you can't go on in life in the United States without a contract. You see them and you sign them all the time. Sometimes you don't even think about it because you're downloading something and it says agree. You don't know what you just signed, but that's a contract. So these are important. That's why I wanted to bring this up, because sometimes these things are not explained to you. And sometimes you want to be a good neighbor and you want to sign these documents because you're wanting to help, right? But you also have to know what they are, because again, they're not always explained, but what they are. And as a sponsor, you have the ability to have your own private counsel explain that to you. But again, in my practice, I don't really see that happening, so I thought it was important to bring it up. Under this contract, the U.S. government can consider the sponsor's income and assets as available for the support of the intending immigrant, whether you're a joint sponsor, just helping out, or you're the petitioning sponsor. And we'll also remember that a joint sponsor does not have to be a family member. A joint sponsor can be a friend, employee, employer, whomever it is, so long as there's U.S. citizens, legal permanent residents, or have valid status to work in the United States. And we see here, and this is exactly what you will see in the actual I-864, and it's a very small, you probably can't see it because the letters are too small, but just be aware that it's there. Be aware, and you'll see it says sponsor's contract on top. What is the legal effect? Make sure you pay attention to these things before you sign. But that's basically what I just explained right now. And so after we know that these obligations exist, then when do the sponsor's obligations end? Well, it also tells you specifically on the form. They end when the intending immigrant has become a U.S. citizen. So they continue until that person becomes a U.S. citizen. Or they have worked and received credit for 40 quarters of coverage under the Social Security Act. So you can always keep track. So once you have your work authorization, you can keep track of how many quarters and how many credits you would have with Social Security. Typically, they'll send you something, or you can look it up online. How many quarters have you completed? So once you've completed 40, which is, I think, 10 years, which is about 10 years, then that means that you're sufficiently able to provide for yourself. The other situation is if the intending immigrant is no longer a legal permanent resident and they have departed. So it may be that they're no longer a legal permanent resident, but they're still here in the United States. Obligation continues. If they're no longer a legal permanent resident and they've left the United States, you don't have that obligation as a sponsor any longer. The other is if the intending immigrant is subject to like deportation or removal proceedings. So if something happens and the intending immigrant is placed in immigration court, and then that immigrant obtains a new sponsor, then your obligation is complete. And then if the intending immigrant passes away. The other way that the obligation ends is if the sponsor passes away. So if the sponsor passes away, obviously we don't have an obligation, financial obligation. But if you happen to have or leave an estate, so if you have either a will or you have property that you have left behind, make sure that there is nothing owed to that immigrant, because that's the only time that the estate will have to pay back what is owed to the government, if anything is owed. And just to let you know, I haven't seen this happen, right? But we're talking about what the obligations are. So these things can happen. And this is part of the language that is also included in the I-864. And it is also important to know that divorce does not terminate those obligations. So if anybody filed for sponsorship and then subsequently that couple divorces, then that obligation continues. So it's important to talk about and know what it is that you're getting into. So now we'll talk a bit about children. So when we're talking about children, when we're talking about our own children, you know, these are things that we have to consider. What's the legal status of our children? And what's the legal status of the parent? So there's certain things, and this is, I kind of wanted to talk about this a bit just so that we are aware of what benefits we can also apply for if we're going through a divorce, if we're going through a separation, and we have children. So there is a type of protection for children that allows for legal permanent residency and ultimately U.S. citizenship for the child if it can be proved to a court with jurisdiction that child has been abused, abandoned, or neglected by one or both of their parents. And what I had been seeing lately is that these were independent petitions that were filed that had nothing to do with a divorce or a separation agreement. But so that you all know, or you can let your friends, family members, neighbors that are going through something difficult like a divorce or separation, that there are these possibilities for their children and these protections for their children. And these protections can be included, and this is just a case law to back up the fact that a court in, at least in the state of Indiana. I focused it on the state of Indiana because that's where I'm licensed. So I can't give you advice on Michigan law. So, but in the state of Indiana, at least, the courts are required to take a look at these different requirements under the Special Immigrant Juvenile Status statute. And again, these are Indiana codes that I included. I don't know, again, I can't give you advice on Michigan law, but in the state of Indiana, I know that people here come from Michigan or Indiana. But in the state of Indiana, at least, when there's an unfortunate situation where one parent dies and the child, for example, is undocumented, then that child can still apply for special immigrant juvenile status because of that parent's death. And so these are things that I see that are not very common or issues and out of the Indiana code that are not being used. So I think that it's important that you know that these things are available because these things happen. They might not be pleasant, but these things happen, and you should know that these are benefits that your children can obtain. And then now we have the U non-immigrant visa applications that Rudy is going to talk a bit more about.
You know, when we're talking about these last points, we're talking about situations where we may not have status ourselves already, either because we overstayed a visa or we came here on a visitor's visa and then we're in the country without valid status. And what Cecilia and I are talking about right now are ways that we might be able to benefit for a visa when you're not going through it the traditional way. So first was, if we have a child that's under the age of 18 that has been abandoned or neglected or abused by either one or both of the parents, that child has an opportunity to obtain legal status. The other is the U non-immigrant visa, which is important for everybody. And the policy behind this visa is that we believe in the United States that it's better to prosecute the person that committed the crime rather than to deport the victim who may be here undocumented. So sometimes people may be victims of crimes, but we don't have status, and we don't want to call law enforcement, or we don't want to tell them that they committed a crime because we're afraid that we're going to get deported. This law protects you. And what this law says is that if you fall under one of these categories, if we can go to the next slide, if you're a victim of one of these categories, okay, I'm putting it the wrong way. There we go. If you're a victim of one of these types of crimes, and you cooperate with law enforcement, then if it gets certified by law enforcement, that gives you an opportunity to be able to apply for a non-immigrant visa, which means that if they approve it, if USCIS approves it, in the end you can obtain permanent residency. And that serves two purposes. One, it protects you, or the victim, I should say, and receives justice for the victim so that they can still cooperate with law enforcement, so that the aggressor or the person that committed this crime is held responsible. And two, it gives you an opportunity to be able to remain in the United States and obtain a permanent residency. The other that I would mention is the Violence Against Women's Act. And this exists if we're the spouse, parent, or child of a U.S. citizen or a legal permanent resident who's abusive, that gives you an opportunity to be able to apply. We talked about the I-130 before. This allows you to apply for the I-360. It's a way for you to be able to legalize your status through what's called VAWA. In this instance, we're talking about an abusive husband or wife, for that matter, and the immigrant doesn't want to report or doesn't want to get out of that relationship because of the fact that because what does the husband or the U.S. citizen say? Go ahead and call the police and tell them that I'm beating you up. I'll call ICE, and they'll deport you. And so then the immigrant doesn't want to call ICE, doesn't want to call law enforcement because they're afraid that they're going to be deported. This affords you protection from that. So it's so that people that are in an abusive relationship can get out of that abusive relationship and still be able to apply for a benefit to be able to remain in the United States without the need to depend on the person that's abusing them. Oh, and that's a really good point. What Cecilia just mentioned, that couple does not have to be divorced. You can still separate. You can still apply for that benefit in the meantime while that's happening. And then the distinction between what we talked about before, the U visa and the VAWA. The U visa, it doesn't matter who the aggressor is. If they're a legal permanent resident, if they're undocumented themselves, if they're an asylee, a U.S. citizen, it doesn't matter. If you're a victim of one of those crimes that we listed before, eligible for the U visa. But for VAWA, for the Violence Against Women's Act, the abuser has to be a U.S. citizen or a legal permanent resident. The other distinction is that in the U visa, you need certification by law enforcement, and in the instance of VAWA, you do not. Just generally speaking, now that I know that we went through a lot, but one of the general things I wanted to share is this. If you come into contact with law enforcement and you're not a U.S. citizen, and first of all, the U.S. Constitution protects us all, right? So regardless of your immigration status, regardless if you're a U.S. citizen, your status does not matter. Here, all of us here right now, we're protected by the U.S. Constitution. So that means that the same rights all the rights that are listed in the U.S. Constitution, we have those rights, which means that if you come into contact with law enforcement, you have the right to remain silent. And actually, that's what we, as lawyers, we always tell our clients, remain silent, right? Because you don't know what you don't know, and whatever you say, it's just like they say in the TV shows, whatever you say is going to be used against you. So you remain silent. We have an obligation to tell them our truthful name, to tell them our name, identify ourselves. From there, that's it. If law enforcement shows up at your house, they knock, and they say, let me in, you do not have to let them in. It's like vampires, right? You don't let Dracula in. If you don't let them in, they're not going to come in the first place, right? But if they knock at your door and they want to force their way in, you have the right to ask them to present you with the warrant, right? Show me the warrant. Show me a document that's signed by a judge that affords you the authority to come into my house. Otherwise, I'm not letting you in. And that's everybody here. We have a right to privacy. We have the right to security within our own homes. People just can't come into our house without that warrant. The other thing I was going to mention is that if you've been charged with a crime, we haven't really gotten into that, but I wanted to be able to provide it generally, that if you've been charged with a crime, let's say driving never licensed, driving as a DUI, right, driving under the influence, battery, theft, it's extremely important that the lawyer that you hire that deals with that case also is a lawyer that knows immigration law or works in partnership with the lawyer that knows immigration law. So because, again, there's certain types of crimes that if you're convicted of that crime could have you lose that permanent resident status that we talked about before. I'll give you an example. Let's say your 18-year-old son well, nowadays we don't have CDs anymore, but let's say, all right, a bottle of liquor. How about that? Your 18-year-old son, who is a legal permanent resident, goes into the liquor store and on a dare, look, I dare you to steal that bottle of vodka. So they steal the bottle of vodka. If that then goes to court and they don't afford him an opportunity to get rid of it because it's their first offense, but if he pleads guilty to theft and receives a year sentence, suspended, meaning he doesn't go to jail, that son has now been convicted of an aggravated felony, which means that he loses his green card and he gets deported for life. Let's say that the lawyer knew what he was doing, and the lawyer says, don't let him plead guilty to a year in jail. Have him plead guilty to theft with 364 days, just one day, with 364 days. Now that son has been convicted of a crime involving moral turpitude, but he's not deported for life, and he doesn't lose his green card. Let's say that the lawyer really knows what he's talking about and says, look, make sure that the sentence is less than 6 months. Pleads guilty to theft, gets a 6-month sentence, now it qualifies for the petty offense exception, and your son doesn't risk deportation at all. And so that's why it's important, like for something as small as, okay, you made a mistake, take responsibility for your actions, not knowing what the consequence can be can have some very serious consequences. And then the other is that a lawyer, especially an immigration attorney, would be able to tell you, well, these are the things where your son is still protected. We can still apply for citizenship later in the future, so forth and so on. The other, let's say that we're unfortunate enough that somebody gets arrested by law enforcement and they're placed in jail. and the local jail places a hold on them, an immigration hold. I don't know if we've had that experience, but it does happen. We should know that the immigration hold is number one, is a voluntary hold, and number two, a lot of times our local jurisdictions, our local jails don't know the power, the authority of that. So when they put an immigration hold on you, an ICE hold, that can only last for 48 hours, not including weekends. So if a person's arrested and you pay the bond and they're like, we can't let him go, he has an ICE hold, if you posted the bond on Monday, by law, they're supposed to be released on Wednesday if immigration doesn't come and picks him up. If they hold him beyond Wednesday, that's a violation of his rights, right? Then you can file a lawsuit and say, hey, let him out. The lawyer would have to do that. But at least we know that if they're arrested on a Monday, but posted the bond, ICE hold, supposed to be released on Wednesday. Let's say it's like today, or yesterday was a holiday. Let's say they got arrested on Thursday. Friday doesn't count because it's a holiday. Saturday doesn't count. Sunday doesn't count. Monday counts. They're supposed to release him on Tuesday if he was arrested on Thursday. So the fact that it was a holiday doesn't count. So then what I'm sharing that is that sometimes people won't post the bond because they're like, well, they're not going to get out. The jail will tell you, don't post the bond. He's not getting out anyway. He has an ICE hold. No. Post the bond, but be strategic about when you post it so that the 48 hours can pass and hopefully they get released. Let's say that the 48 hours, they don't get to 48 hours and ICE does pick them up. Well, then know that if they go before a judge, they're entitled to a hearing. And so the other thing is that we should all know and tell our friends who may not be U.S. citizens is that if immigration ever picks you up and places you in removal proceedings, everybody, that's the beauty about being here in the United States, everybody has a right to see a judge. And ICE will try to be slick and say, sign the document. You don't have a right to be here. We're going to deport you anyway. If you don't sign this, you're going to be in custody for like 4 months, 6 months. So you better sign this now so we can just send you home and that way you're not in custody. No, don't sign it. We're going to say, no, I want to see a judge. And when you see the judge is going to determine whether or not you're entitled to a bond. And then now all of a sudden we may have an opportunity to legalize our status that we did not have before. So for example, sometimes you'll hear, hey, I've been in the United States for like 20 years. Can I legalize my status? Well, there was a law that they've been talking, there's a representative in Texas that has been talking about extending it. There is a law in the books now that says that if you've been here since January 1st of 1972, just because you've been here since then, I don't know how many of us are that old, I am, but if you've been here since January 1st of 1972, that's called registry. You just prove that you've been here since then, you're going to get a green card, right? But who was born in 1972, right? Or 1971, right? The other one, though, that exists is this, that if you've been in the United States longer than 10 years, you have good moral character, and if you can prove that if you were deported, your U.S. citizen or your legal permanent resident parent, spouse, or child would suffer an extreme and exceptionally unusual hardship if you were deported, they cancel your deportation and they give you a green card. That's called cancellation or removal. So a lot of us don't know about that. So that's the one that exists. So sometimes somebody will get arrested. It's all about, I talk to my students about this, it's all about public perception. Sometimes people will say, well, how come I can't legalize my status? My friend got arrested on a DUI and he has a work permit now. And it's not because he had a DUI that he got the work permit. What happened was, got the DUI, had an ICE hold, immigration picked him up, placed in removal proceedings. Then the lawyer saw that he was eligible for cancellation or removal. While you're waiting for this application to see whether or not it's going to be approved, you're entitled to a work permit. That's what it is, right? It's that different situations call for different solutions. But I want us to be aware that if we've been here a long time and we have children that were born in the United States, that there may be an opportunity for you to be able to legalize your status. And then I guess the other one, generally speaking, I would say all of us have rights, regardless, right? All of us are entitled, like we were talking about earlier today, to be treated as human beings. We're all protected by the United States Constitution. And so even if people mistreat you or if people try to tell you that you don't have rights in this country, that is not the case. We all do. And I hope that at least with the information that we were able to share today, that at least now we're empowered and at least you have a general idea. But if you have any further questions, the good agencies to look at, we talked about before, uscis.gov. Another one that I'll share with you is AILA, the American Immigration Lawyers Association, AILA.org. Or also we have La Casa de Amistad that's over in South Bend, where we do a lot of work with the community and with regard to immigration and just general community support. So with that, well, I'll end the presentation here and then open up for questions if anybody has any questions. Thank you.
Thank you so much, Rudy and Cecilia. I don't know if you can talk a little bit about DACA, because I know it's been in the court system, so I don't know if what the situation is with DACA.
Yeah, so DACA is that if you enter the United States when you were before the age of 16 and either graduated from high school or in college, or if you joined the military, that afforded you an opportunity to be able to have protected status. And the beautiful thing about DACA was that it also affords an opportunity to be able to travel outside of the United States. It's called advanced parole. That if you had unlawful entry in the past, I would recommend that one would take advantage of that, aside from the fact that that allows our children who may have not been back in their home country since they were kids to see their country now. It's in a real precarious position now because there is a lawsuit in Texas, and unfortunately recently it was not overturned. The court's decision was that DACA was unlawful. The Biden administration has introduced regulations to try to cure that, but it's going to be up to the Supreme Court to decide whether or not DACA should continue in the way that it is now. So the status is that if you've had DACA before, you can continue to renew. You can continue to apply. If you just become eligible for DACA, you can apply, but the district court said that they cannot adjudicate it. So if you have somebody that just qualified for it because they just turned of age, they can apply for DACA, the Deferred Action for Childhood Arrivals, now, but the USCIS is not permitted to make a decision. But I would say that it'd be worth it to turn it in because we never know what's going to happen, right? I'll give you the best example with DACA. There were youth in the United States that were frustrated with the system. They kept on talking about passing the DREAM Act, and it didn't pass. And there were folks that were frustrated, and they left. They're like, well, I'm going to go back to my country. So they went to Mexico. They went to wherever they were around the world. And then while they were outside of the United States, then DACA passed, and they're like, oh, we should have stayed. But there's people that are doing, I always talk about this one student that was from Mexico, would have qualified for DACA, got frustrated, and now he's getting his doctorate at Cambridge, and might be the one that's going to give the cure to cancer. And so England's going to get that benefit. We could have bragged about him, but we didn't think that the DREAM Act was something that we could pass. But anyway, the point is that if you are eligible for DACA, apply for it. If it's the first time, you're not going to get a decision, but if it's a renewal, you will. So there's still people that are still obtaining renewal status on those DACA applications.
And just one thing to add. Don't let, if your DACA has expired, don't let more than a year pass before renewing, because then you'd be considered a new applicant, and that new application is not going to be processed, as Rudy explained. So do not let 1 year pass or lapse from renewing.
All right, thank you so much. Now it's questions. If you have any question, what episode busa ochi no which me busa ochi na ya translation. Omo I dey so omo be boy, so don't let it my mom omo kosa. Yes, go ahead.
Hello.
Hello.
Yeah, I'm Daniel. I'm a student at Andrews. I got in and then I was told that I'm working with an I-20. I'm living on F1. And they were working on a document to move me from the initial status to the continuous status. Then there came an opportunity that I had to travel to another state to see my brother. Then there was a call that I cannot travel because the the initial status have not changed to continued status. At what point in time does an F1 with still living on I-20 change to a permanent status?
So, generally speaking, when somebody comes in on an F1 and is going to be a student, one of the opportunities that you can have as an F1 student is you can apply for an H-1B. An H-1B is it's where you have a specialty occupation, and that allows you to have a temporary work visa. So when one graduates from the university, while they're in the process of going towards graduation, you would need to find an employer that's willing to sponsor the F1 or an H-1B visa, and that's a way that you might be able to afford. The H-1B then allows you to have dual intent. So if you qualify because you have a bachelor's, that employer can also sponsor you for an immigrant visa, that's the employment-based. So while you have an H-1B, you can also seek to apply for permanent residency. It's one of the few instances in our immigration system where you're allowed to have that dual intent. The other thing is that if you don't have an H-1B when you graduate, you can also apply for what's called optional practical training. And optional practical training allows you to be able to work for a year while you're seeking this opportunity to be able to have an H-1B or, the H-1B. The other thing I would mention is that for those of us, again, if we entered lawfully and we have this F1 status, if we have children that are born in the U.S., when those children turn 21, they'll be able to petition for us as well to legalize their status. Or if you're married to somebody who's a U.S. citizen, then you have an opportunity to be able to legalize your status, or a legal permanent resident while you're still a student, such that you're still in lawful status. That's another means for you to be able to apply. So that's an employment-based petition that's available, and that's a family-based petition that's available. But just to reiterate, with an F1, you would F1, OPT, H-1B, and then at the same time, a path towards permanent residency.
So for Mami.
Thank you very much for coming and helping us. My question is more tailoring to maybe, let's say, F1s or non-immigrants, kind of a thing, coming here. To what extent can they accept social help? So let me give a typical example. So if you are a female and you come here and you're not a US citizen, maybe you get pregnant. You want to get some help because when you're in school, sometimes it's not all that easy. And we also know that the government have rules and regulations with regards to how much help you can get. So can you dive into how help students can get in that perspective, since the majority of us are in that kind of pool? Thanks.
So thank you. That is a very good question, because when I spoke about earlier that there are certain exceptions to those benefits that one can receive from the government. So being pregnant and obtaining health insurance during that time is seen as an emergency, and so it does not count against you. So for example, if you are pregnant, just in the example that you gave generally, you should be okay, because it's seen as emergency. So it's not going to count against you if you want to, when later you can adjust your status. This is also the case if, this is for F1s, but then if you are under that U visa or that VAWA, you can obtain full health benefits from the government, and sometimes even monetary assistance from the government. Same thing with certain either asylum seekers or refugees, same thing. So you may not be a legal permanent, or you may not be a United States citizen, but you can obtain those benefits. And so these are the exceptions that I spoke about before. So you shouldn't be scared to request that, because it is seen as an emergency situation.
Mami Efum.
I speak my language. Me pawisho. Me kase mono wakan se bi a waware. O pese. ukunu no won krata, wu ni krata. Ena yesi ko na waba. Enam se ba be ye overstay no. Me ye den na makọ na masama bi. De minim se wo konso a ye ma won sa ama. Na me ye den. Emra me so se tena kuro mama ware. Me ye den.
I couldn't understand her right from the because my mind was there. Mommy, can you begin?
Oh.
A little louder. Bring
I'm
the.
sorry, I speak my language.
Okay.
They say, my be worry, my ba, as a second ko, man ko, and my worry. The castle no can say, ko, na wa saba. Miss me buy and man come a bay overstay, may a day na ma ko, na masama bamra me qua, ya mamma. Miss Mikuno, a may a day.
Okay. Yes. I'm here in US. I'm married to my husband. I have overstayed. Whilst you were talking, you said, since I have overstayed and I want to apply for a document, I have to go back to my country. But I know very well that when I go, they will not give me the visa to come back. I have married my husband here. How can I go and then leave my husband over here? I'm already here, married to my husband. I have overstayed. The husband is a U.S. citizen. Yes.
Okay.
So should I go and leave my husband since I know that when I go, they will not allow me to come back to join my husband? Thank you.
So there's, that is an excellent question. Is somebody translating what I'm saying?
Yes. We and someone about
Okay. So, the first step is you file, the first step is identifying, I'm not even going to talk about establishing whether or not the marriage is legitimate. You look at how did you enter the United States. If you entered the United States lawfully, you do not have to leave the country. You can apply for your green card here in the United States. If you entered the United States unlawfully, in other words, you did not have a visa, then you have to leave the United States. But first you identify whether or not you fall under the 4 exceptions. Did you not have a visa, but they let you in anyway? And believe it or not, it happens. They tell you, you can't come into the country, but they waive you in. That's the fact that they waived you through was Areguin, the case that we just talked about, that they waived you through. The other is that you had DACA maybe, or some other reason to travel where the government let you travel and you came back with advanced parole. That's the other one that allows you because you entered lawfully. The other one is you filed the I-130 before April 30th of 2001, then you pay a fine of $1,000 and you can still legalize, you don't have to go back. The last one is what we had talked about, which is military parole in place. Your family members, or your son, your parent, or your spouse was in the military. But in that situation did I enter lawfully? Then then it's the near perfect case. You can apply for your green card here in the United States. If you did not enter lawfully and you leave, you won't be able to come back for 10 years. But you can turn in a waiver while you're still here that says, in other words, forgive me because I entered unlawfully and I've been here longer than a year. And if you prove that your husband or your spouse would suffer an extreme, or your parent would suffer an extreme hardship, then they waive it. So then you go to your country, you go through the interview, and you come back, presumably in a week or 2, or whatever time it takes, but you do get to come back. You knew that the bar was already taken care of beforehand. What?
Well,
You heard what he said?
how do you prove?
How would you prove that, Antonio? Does he have a microphone? That's a great question. We just talked about it in class. How would you prove that they waived you in?
Proof being waived in, you could do a multitude of things, have witnesses that who were there, talk to the officer or whoever was at the border or at customs who waived you in. There's also the fact that, there's one more. FOIA, you could ask for information for the total waive-in process to prove that you were essentially waived in. That will suffice the inspection.
Right. So what he was saying was there's a tool that immigration that we all are entitled to. It's called the Freedom of Information Act request. What that says that if there's any agency in the country, anything, BMV, the newspaper, anybody, police, if they have any documents about you, you have a right to get a copy about it. So you submit a FOIA application to the Customs and Border Protection, and that's online now, and then you tell them, I want paperwork that has anything to do with my entry into the United States on that date or during this time period. They give you everything that they have. If you're lucky enough, they will have documented that they let you in. If you're not lucky enough to have had that, then what Antonio had mentioned is that you can have people that were there submit affidavits to show that actually they did allow me in. And the other is, like, if you're, let's say for example, you have the flight, you have proof of the flight, you have your passport. If you don't have the direct evidence, you can still support it with secondary evidence to be able to demonstrate that. It doesn't mean that you're going to be successful, but at least it shows that you're standing with this position that was the case.
Okay. Talking about the waiving process, does it require a lawyer or judicial person, or it's something that you can just do it yourself?
No, everything. It's like I like to describe applying for immigration status like submitting your taxes. I can do my own taxes. When I was in high school, I did my own taxes. Right when I worked at McDonald's at that one spot, I did it. Now that I run a business, I hire someone else because they know all the intricacies as far as filing tax returns are concerned. Same thing with immigration. If it's pretty straightforward, you can do it yourself. All of it, you can do it yourself. But you don't know what you don't know. And so then I'll give you a better example of that. Sometimes people, the USCIS website will tell you in order to apply for your spouse, you have to turn in the I-130. Well, what they don't tell you that a lawyer would know is you're supposed to submit proof that the marriage is legitimate. You're supposed to show proof that the two parties are legally enabled to marry. Sometimes people may worry, with this relationship, I don't have a son or a daughter or a child. How am I going to prove that this marriage is legitimate? Well, the lawyer knows you show joint assets, joint obligations, affidavits from people that know the relationship, pictures, photographs, text messages. So it's just that you can certainly do it yourself. But sometimes there's an advantage to having somebody that has done it many times before so that they know what to provide. And the other thing I can mention is I would go to AILA, AILA.org, because they also will afford you individuals that do it in the area that don't charge, right? So if it's a matter that you can't afford an attorney, there's nonprofit agencies that will assist without charging. And then AILA also lists those that we trust that know what they're doing, and so then if AILA vouches for them, generally speaking, they're going to be lawyers that we can trust.
And we'll have time afterwards if you have specific questions about your personal circumstance, then we'll have that one-on-one and we'll be able to speak with you.
Thank you again. If a student, by virtue of maybe course requirements or whatever, loses status, what is the condition of that student?
It would be so the same as for example, someone that came in on a tourist visa and remained after the period of time, then they would be undocumented at that time. So they would fall out of status. This, again, an attorney would be able to tell you, right, that just because you fell out of status does not mean that you can't adjust your status. So depending on everybody's situation, there's still something that may be able to be done even if you fall out of status. So you may not be able to, well, on an F1 you're not supposed to be working, but if it's like a different type of status, right? Like if you have DACA and you fell out of status and you didn't renew, then your work authorization doesn't work anymore. If you had an asylum application and, well, generally, if you have an asylum application and then you withdraw that application, then that work authorization no longer is valid. So it just depends on each person's situation and what benefit they can get from having entered the United States lawfully. Coming in on an F1 is a lawful entry, so you still have those benefits.
Okay. All right. My question is still on the issue of a visitor who has come to this country. I wanted to find out if the laws have changed. I remember during the time of President Trump, we heard so many stories regarding visitors who have overstayed their permit here. If I'm a visitor, I come to this country and I have overstayed, do I still have the opportunity to marry someone who is a citizen? At that time, I was hearing so many stories, so I wanted to know if that's one. And then the second question is, if I want to process my documents to become a citizen, and since you are based in Indiana, do I need someone who is based in Michigan to work for me to get that process done?
Oh, that's an excellent question. We just went over it. So during the Trump administration, there was what was called the 30, 60, and 90-day rule. And that was that when you entered the U.S., if you engaged in certain types of activities, it was presumed that you did not have the required non-immigrant intent. So when you have a B1, we talked about non-immigrant visas, that's when you have a J1, an H1B, a B1, an F1. You're not intending to come to the United States to stay here. You're intending to come to the United States for a specific purpose, which is the F1 to study, the B1 to visit, and then you would go back to your country. So then what they were talking about with the 30, 60, and 90-day rule was that if you, for example, got married and it had only been 30 days since you entered, then they were like, wait a minute, you're in violation. Then you didn't intend to come here to visit. You intended to come here to get married. But what I would say is that if you're beyond the 90 days, there's no restriction on, life happens, right? We came here to visit, you overstayed your visa, you fell in love, or, and you wanted to get married, and you didn't know that he or she was a U.S. citizen or a legal permanent resident. You just knew that you were in love. You can get married, and if it so happens that they're a U.S. citizen or a legal permanent resident, you can still apply for that immigration benefit. And then the other question, when we talk about lawyers in immigration law, if it's state-specific, so when I was talking about crimes and Ceci was talking about the divorces and family law, that you need to have somebody who's licensed in the state of Michigan or in the state wherever the issue may be, when it's state. But when it's federal, which immigration is, taxes, if you ever are charged by the U.S. Attorney's Office, that's federal. That's bankruptcy. Then that's any lawyer that's licensed in the state, in a state in the country. So we have clients that are in Michigan, Indiana, California, Texas, because the work that we do as immigration attorneys is federal. So then when it's immigration, so long as the lawyer is licensed in the state in the country, that lawyer can assist you.
A question, please. Oh. Go ahead. I'm a young lady here with my husband. My husband is F1, I'm F2. Can my stepsister file for me?
Okay, so generally speaking, if somebody's here on whatever status, absolutely, whoever your family preference, they can apply for you. To establish that relationship, anybody can apply for anybody, right? If you have that relationship, it's my stepbrother, it's my stepsister, it's my mom, it's my dad, my brother, my sister, my child, married, unmarried, they can file for you. That's the first step. It's the foundation to say I'm entitled to an immigrant visa. Whether you're going to be able to get to the next step, adjustment of status or consular processing, that's when the lawyer needs to analyze whether or not you're going to be able to. So long as somebody, in order to adjust your status in the U.S., you have to have entered the United States lawfully, and you have to have been in the United States lawfully in order to adjust your status. The exception is for immediate relatives or victims of VAWA, as another example. With immediate relatives, what's important is that you were inspected and admitted or paroled, that you entered the United States lawfully, or that you fell under one of those 4 exceptions that we talked about before. If you worked unlawfully, or if you overstayed your visa for an immediate relative, that does not bar you from adjusting your status. You can still apply for that green card. But that's not the same for everybody else that fell on that chart that we saw before. So it just depends on on what status you have at the moment that you're applying and under what category you're seeking the immigrant visa.
If they require for a DNA, will that work?
Such a good question. When we ask for DNAs, that's when they're trying to prove the relationship and that you are a stepbrother or stepsister or biological brother, biological sister. USCIS will tell you what agency they want you to go through to be able to prove that relationship. It all goes back to our parents. If it's the natural mother or the natural father, if it's the natural mother, it's going to be a lot easier to be able to prove your case because it's mom. But if it's the natural father, they're going to look at, were they married at the time when you were born, or was the child born out of wedlock? And when the child was born out of wedlock, that's when USCIS may ask for DNA results to be able to show and prove that relationship.
My last question, sir. Can F2 change to B1 or H1?
So there, right, you can, in certain circumstances, adjust your status to change your status to a different status, right?
Yes.
And off the top of my head, I cannot remember, but I can look it up. But there is a possibility. There's certain types of visas, like an F1 or a J1, for example, that require you to leave your country, and then wait a certain period of time and then come back. For example, J1, you have to wait 2 years. There's a waiver for that. And so I would have to look up the situation for an F1, but there is a possibility that you can change your status. For example, if an employer hires you, right? You can change your status to that. Not necessarily to a B1, because that's a visitor visa. That's something that you get abroad at your embassy. But you can change your status to something, to a different type of visa. So there is, you have to keep on taking classes. You cannot get out, you have to be in school. The purpose of the F1 is that you are studying. So if you are not studying, then you fall out of status. Unless, of course, you get hired, right? And now you can change your status to a work visa. But you have to remain in school. If you fall out, and I've seen it happen quite a few times, you fall out of status for whatever reason, things happen and you can't continue to go to school. I mean, when I was in school, there was a period of time that I had to stop going to school, right? Things happen, but the government doesn't understand that. Yeah. So So generally, you have to remain, unless of course you talk to your school and your school is, but you tried that, right? But generally, if you talk to your school and your school is willing to be flexible with allowing you to take, because for F1 you have to have certain amount of credits to be considered full-time or considered to be a student. So if if there's a way that you can talk to your school and if they're willing to do something about it, but otherwise you have to stay, you have to stay in school. The other issue, so the other issue about finances, again, the F1 presumes that when the non-immigrant comes to the United States, it's because they can afford to go to school. So they don't build in that flexibility, unless what Rudy talked about, which was OPT, but that comes after the fact, right? So
But there is a limited circumstance where you can actually get authorization to work, but that's the double-edged sword, right? Because in order to be able to get that authorization to work, you have to demonstrate that you have this need to, but then that contradicts why you obtained the F1 in the first place, which was that you don't have the need, that you have the means to be able to apply for it. But there is that opportunity where you might be able to have some work authorization while you're still in school. It's just very limited. And then the other thing I would say is that, and that's what Cecilia was talking about, that we understand that people have different circumstances. I think the really important thing that we want to remember is it's so important, the fact that you had that lawful entry. The fact that you had that lawful entry really affords a lot of opportunities later in the future. And you never know what happens, right? God forbid that you should be a victim, that one should be a victim of a crime, or that one should suffer anything. But like what we talked about before, that affords you the opportunity to be able to get some means of protection. And the other is that if you had that lawful entry and you had a child that was born in the United States, that child is going to be able to petition for you. And when that child turns 17, if that child decides to join the military or do the National Guard, you're going to be able to get a work permit based on the fact that your child is in the military. So for me, it's difficult to say that I don't think it's difficult to say that we should serve our country. What's difficult to say is when you recognize that that it's not for everybody, right? Some people want to go to college, and that's what they want to focus on. Or some people want to work. Some people want to serve our country, and God bless them for doing that. And one of the benefits, if that's the case, is that their parents, spouse, or children will be able to get a work permit in the meantime until they're able to fully petition for that individual. So even if you fall out of status, I don't say that that's the end all. It's just a matter of seeing what other opportunities are there, or what other benefits are there, or what other protections may I have, such that I can still remain in the United States.
There's other situations where I've seen where the person has an F1 and then they no longer were able to continue with their studies, but they were, for example, afraid to go back to their country, and now that person has. We didn't talk about this, but now that person may be able to file a asylum application if they fear going back to their country for many different reasons, right? If your fear is subjected to you, so if you feel that you are placed in a position where you fear going back, but you can't no longer continue with your studies, then there's a possibility to file for that asylum in different ways. Affirmatively or defensively if you're in immigration court. Filing that petition and having that petition pending allows for work authorization. So, I mean, I've seen that happen as well because it happens for many different reasons. People come to study, but that doesn't mean that, you went through something when you were in your country or on your transit to the United States. So, right, or change circumstances. When you were in your country, everything was great, everything was perfect, but then you came to the United States, you started studying, something happened in your country where it's no longer safe to go there, and because of one of 5 different reasons, you fear going back, your religion, your nationality, your political opinion, particular social group, then you can file for asylum here because of changed country conditions. So that's another possibility.
Thank you. We all know that F1 students or visa holders are supposed to work 20 hours in a week. And let's say because of financial difficulties, you work more than 20 hours throughout your stay. And after school, you would want to stay. Can it pose a problem for you after school if you want to stay?
Yeah, generally speaking, that if you're in violation of the conditions for which you were giving your F1, it can cause an issue. But they'll have to take a look at the case as a whole, and it depends on what you're applying for. So, for example, let's say that then you become eligible to adjust your status because you're an immediate relative. That's not going to be an issue. But let's say that you're applying for an H-1B. That may be an issue. So it just depends on your circumstance. And then USCIS is going to depend on the information that they have readily available to them. So if they don't have the information, they may not use it against you. But if they find out about it, they can.
All right, maybe a couple more questions if there's any.
Yeah, when somebody asks a question, after, let's say I finished school, I have graduated, and the school give me 1 year to work. And my profession is nursing or a minister, and I couldn't get that kind of job. Can I use that visa to do any kind of job?
So, it's not like you want an answer. The answer is when you apply for an H-1B, it's specific to that employer and in that specialty occupation. So it's not to do any type of work. It's with that employer and that type of occupation. If you receive a work permit based on what we talked about before, then you can work in whatever area. But when it's specific to the type of visa that you have, it's to that specific employer in that specific specialty occupation that one has. So that would be the answer generally.
But then you just have to be careful about falling out of status for purposes of a work visa, because then you'll have an issue of unlawful presence, and that can cause an issue for your employer that's willing to sponsor you.
All right, we have time for one more question. In the meantime, Opie, if you can put, we created an address card for you, Rudy. If you can put it on, okay. If you want to take a picture of it, and then you can call them if you have any questions, any issues, or anything like that. And then if there's no question, we're gonna have lunch. And after lunch, they're gonna be in pastor's office. So if you have a personal question that you want to consult them or ask them about, you're more than welcome to do that. So at this time, I will take this opportunity to thank you again, Rudy and Cecilia, Antonio, Shannon. You're welcome for making time out of your busy schedule to be with us today. I know Rudy is very, very, very busy. He's a busy man. So we're so glad you're able to make it, Rudy. Somebody is trying to ask a question on Zoom. That's why I'm checking on my phone. He said he cannot access Zoom, Kwame. I cannot access the Zoom or the same. I'm watching live, so I don't know how he's watching it. Maybe on Facebook. Okay. In the meantime, I'll ask Pastor Akobsa to come over and then say a final prayer for us before we go eat.
All we can say is thank you so much for coming to educate us. We really, really do appreciate it, and we are hoping that hopefully next year we'll be back. So we want to make it a tradition so that at least every year you come here and educate us. We are very grateful. And to you, church members, thank you so much for staying calm and asking all your questions. I know some of you still have questions to ask them, personal questions, so please let us know after lunch. You can meet them and ask them. Let us stand as we Our Father in heaven, we thank you once again for what you've done for us. We want to thank you for using the Mount Teresa Law Group to educate us this afternoon. All we are asking is that, Lord, be with them, bless them, lift up your countenance upon them, and bless us as well. We lift the food that we'll be eating this afternoon into your hands, that you will go ahead and bless this food and sanctify it with the blood that was shed on Calvary. That when we eat, it will nourish us. Thank you, because we prayed with faith in Jesus' name. Amen.